Ismaila was detained in Nigeria's Federal Capital Territory for criminal charges that he denied. He could not afford hiring a lawyer and was unable to notify his family. He spent 4 months in a custodial center before his first trial took place. He then continued to wait for months. His case was adjourned 13 times, despite legal requirements for faster processing. Thanks to the initiative Reforming Pretrial Detention in Nigeria, or RPDN, a team of pro bono lawyers and law clinic students took on Ismaila's case. They notified his family, represented him in court, and provided other pro bono legal services that eventually led to his discharge. In Nigeria, many pretrial detainees find themselves in a situation similar to Ismaila's. The government is making efforts to improve access to justice for them. The Administration of Criminal Justice Act of 2015 requires a more efficient and speedier provision of justice while prioritizing the human dignity of victims and defendants. Despite these reforms, the majority of inmates in correctional centers around Abuja are waiting for their trials in overcrowded cells over weeks, months, and some for years. Many of them, and especially those from marginalized communities, cannot afford legal representation. RPDN supported the government of Nigeria to ensure pretrial detainee cases are being processed in line with the new law. Pro bono duty solicitors provided pro bono legal aid at police stations.
Police Duty Solicitor Scheme is a scheme that ensures that detainees in police stations are offered free legal services. In order to determine who receives these free legal services, interviews are conducted. For those detainees who are indigent and have committed misdemeanors, legal services are provided in one way or the other.
There are some cases that do not really need to go to court. We're able to mediate on some of these matters and also encourage the police to mediate on these matters.
RPDN also supported the correctional services to institute a digital case management system.
The Corrections Information Management System is a digital system that is built to support the Nigerian Correctional Service to digitize their process from the stage of registration of inmates, admission, and the process of legal representation.
The Correction Information Management System, it's an electronic software that contains the data of every inmate in accordance to their category, be it a lifer, that's inmate on life imprisonment, IDR, inmate on death row, convicted inmates that are no IDR or lifer that just have years of sentence, as well as their waiting trial inmates.
It helps to identify the gaps within the justice sector that informs reform, and then also tracks the implementation of the Administration of Criminal Justice Act in a way that it reduces pretrial detention, provides legal representation, and also enhances coordination amongst the justice sector stakeholders.
Law clinic students and lawyers provided pro bono legal aid for inmates identified via the digital system.
My experience with the RPDN project has made me aware of the social injustices in Nigeria, and then made me a socially inclined lawyer. So I am certain that being a legal practitioner in the future, whenever I finish my law school and then get called to the bar, I would not be a regular lawyer. I'm going to be a lawyer that is socially inclined, because I'm aware of the social injustices in Nigeria, basically becoming a public interest lawyer in future.
Courts developed a digital case tracking system and started the digital transcription of hearings.
Transcription equipment assists the judge or the magistrate in having an accurate record of their proceedings in court. In the past, assuming you have pretrial detainees and let's say the cases listed are about 15, by the time the evidence goes on, it gets to a point, the judge, being a human being, gets tired. But now the court is assisted by this equipment. That means the judge is able to take more cases and that means cases are disposed of more speedily. The period we spent awaiting trial is reduced because the court docket is not as heavy as it would have been if these equipments were not there to speed up proceedings.
And they arrested me in Lube here to Galadimo Division. From there, they took me to the SACS. I was in SACS for 8 months before they took us to Kuji. I was in Kuji before I met a lawyer. We went to the court, and then they tried their possible best to fight for me to get the bail. So my judge granted me a bail.
So I was there for like 2 weeks in the prison. So before a lawyer and my family came to bail me. After the bailing, my brother introduced me to RPDN lawyers. The lawyer from the RPDN has been representing me in the court for the last 6 months. They've always been showing up for me, even without charging me, collecting any amount from me.
Peer exchange and learning in Nigeria and the US nurtured the future generation of social justice advocates.
15 students traveled to the US to have an interaction and exchange with US students. This is very important in their growth as lawyers, and also their understanding of the different criminal justice systems. Again, it is this exchange activity that brought about the opportunity for 149 students to interact with other students from the US and their teachers and so on in a virtual exchange. It is under these exchange activities that there was a mentoring system. This enabled about 52 students to get mentored by teachers and students and fellow students from the US. They are not just going to be lawyers, but they are going to be socially responsible lawyers who have the requisite empathy and the understanding of the social justice issues involved in the society. They are going to be the right public interest lawyers that the society will need.
As a result of our advice, as a result of our discussions, our trainings, our exchanges, that the students were actually able to go into Kuje prison in Nigeria and actually see that people were getting released as a result of their work.
I think some of the U.S. students who participated in the later parts of the program also had their eyes really opened and were able to think about our own system with some rose-colored glasses off, if you will. So I think that was a real benefit. Right down to the last project we did, even on video, I do think it was very helpful that we had several in-person exchanges and we knew the teachers and we had seen the teachers in action, and so we could see how excited and creative they were.
The courts in the FCT institutionalized changes that RPDN has promoted.
One of the positives of the RPDN project is the installation of the PMS, that is the Performance Management System, in the FCT judiciary, particularly in the magistracy. And this allows for effective tracking of cases from inception, that is from filing till when the case is concluded. Policies implemented over the course of the RPDN project. Number one is monthly visits of magistrates to detention centers. This has really reduced the incidence of pretrial detention in our police stations and custodial centers. And also the non-custodial measures taken, diversion measures, rather than an arrest or detention of a suspect. You can use diversion programs like restitution, and with that, it reduces the incidence of pretrial detention.
Other justice actors are taking action to perpetrate changes promoted by RPDN.
We are innovating, especially in the FCT, how to revolutionize pretrial detention through the use of technology. The whole essence of keeping people in detention is to ensure that they attend their trial. So if we have a data management system that keeps people's data, if someone is standing trial, he doesn't have to be in detention if we know that there are other ways of ensuring that he attends his trial. So if you have your, say, identity card, a citizen's identity card or any other card, without which you cannot do transactions, that is unique to you. It has all your biometrics. You cannot just run away. So we know that if you have that information, we can always get you, except for offenses that are so grievous that it will not be in the interest of the society to allow those persons to walk free on the road. That other persons standing trial can continue with their normal lives while the trial process continues, because we have other means of ensuring that they attend their trial. But this may require amendment of the law. This may require an improved identity management system, but we are working on all that.
Universities have adapted their standing law clinic curricula.
A lot of the aspects of the RPDN project has now been integrated into our law clinic curricula. We have a topic or topics that cover the areas that we have gained from her. We've always had a course called Clinical Law and Moot Court Practice. That is a mandatory course for 400 level law students. So the gains from this project have also been incorporated into that course. For instance, it's now compulsory for those taking that course to go on client interview and counseling to the detention centers, to police stations, to get involved in these processes as a practical component of that course.
Law clinics have made it easier for lawyers and other actors and giving these services to continue giving out these services. Law clinics go to interview pretrial detainees, carry out all pretrial activities with the detainees. In fact, most times lawyers only have to come to court and argue in court or supervise these clinicians. But every other aspect of the pretrial activity or pro bono activities are mainly carried out by clinicians, and it has made it easier for lawyers to go on with their main work as legal practitioners and also give back to society by providing pretrial services and pro bono services.
The project continues to increase access to justice for pretrial detainees and their communities.